Welcome back to AI Unraveled, your strategic briefing on the business impact of artificial intelligence. It is Friday, December 26th, 2025. Today we are looking at the rule of law, specifically Bill C-27, the legislation that transforms Canada's approach to the digital economy from a guideline-based system to a penalty-based regime. The era of voluntary compliance is over. With the introduction of the Consumer Privacy Protection Act and the Artificial Intelligence and Data Act, the Canadian government is putting a price tag on non-compliance: $25 million. If you are building high-impact AI systems or managing consumer data, the margin for error just vanished. We will break down exactly what biased output means in the eyes of the law, why the new privacy tribunal changes the enforcement landscape, and why your data deletion policies might be illegal under the new rules. But before we dive into the legislation, stop marketing to the masses. Start briefing the C-suite. You have seen the power of AI Unraveled, zero noise, high signal intelligence for the world's most critical AI builders. Now, leverage our proven methodology to own the conversation in your industry. We create tailored, proprietary podcasts designed exclusively to brief your executives and your most valuable clients. Stop wasting marketing spend on generic content. Start delivering must-listen, strategic intelligence directly to the decision makers. Ready to define your domain? Secure your strategic podcast consultation now at the link in our show notes. This podcast is created and produced by Etienne Newman, senior software engineer and passionate soccer dad from Canada. Now, let's unravel the law.
Welcome back to the deep dive. So, you gave us a stack of sources on this massive legislative overhaul, and our mission today is to give you the clearest possible overview of what is changing.
It's a huge shift.
Yeah, if you run a business, this tells you what you need to do to stay compliant. And if you're a consumer, well, this is all about reclaiming some control over your digital life.
And that's really the core tension here. I mean, these changes, they've finally recognized the reality that data is just constantly flowing across every border, every geographical boundary.
Right.
And that all major economic activity today relies on analyzing and exchanging personal information. The law needed to catch up.
Okay, so let's unpack this. The goal isn't just to catch up, it's to fundamentally shift the power balance. We're talking about balancing your individual right to privacy, which is, inherently linked to autonomy and dignity, with the needs of the organizations using that data.
Precisely. So we're looking at two big interconnected pillars here. They're both part of the Digital Charter Implementation Act, 2022. We're going to split our deep dive into the rules for handling personal data. That's the Consumer Privacy Protection Act, or CPPA, and then the rules for applying that data in automated systems. That's the Artificial Intelligence and Data Act, AIDA.
All right, let's start with the CPPA. This is the new rulebook. It governs how personal info is protected whenever it's collected, used, disclosed, basically anytime it's part of a commercial activity.
Yeah, and for anyone familiar with the old system, this replaces a big part of PIPEDA. It introduces a much, much stronger set of obligations for companies.
And the foundation for all of it is accountability.
It's mandatory. It all starts with something called the Privacy Management Program, or PMP. This isn't just a suggestion. Organizations must have a formal, documented program.
So what does that include?
It has to have specific policies for data protection, a process for handling complaints, mandatory staff training, all of it documented.
And what's really crucial here, I thought, is that it's not a one-size-fits-all thing.
No, absolutely not.
Organizations have to tailor their PMP based on the volume and the sensitive nature of the information they control. So a huge health tech company is going to have a very different program than, say, a local flower shop.
Exactly. The law demands proportionality. The scale of the system has to match the risk. Now, shifting to maybe the most controversial part of old privacy law, consent.
Right. Those endless, confusing terms of service agreements that we all just click agree on without reading.
Those are exactly what this legislation is targeting.
I thought so.
Consent is still required, but it's only considered valid if the organization first gives the individual clear, understandable details on three specific things.
Okay, what are they?
First, the purpose. Why are they collecting it? Second, the manner in which it'll be handled. And third, and this is the major shift, the reasonably foreseeable consequences of those actions.
That phrase, reasonably foreseeable consequences, it just jumps off the page. It demands real transparency.
It does.
So if a social media platform plans to sell my usage data to some third-party ad broker, They can't just bury that in paragraph 47 of a 10,000-word document anymore, right?
Precisely. The law forces them to state the outcome explicitly. No more vague language to cover, a dozen potentially intrusive uses. If selling your data is a foreseeable consequence, it must be disclosed up front.
And it also forbids getting consent through subterfuge.
Yes, which means no deceptive or misleading language.
That's a huge win.
Yeah.
Before we move on, what about sensitive info, especially for younger users?
For the purposes of the Act, any personal information from a minor is automatically considered sensitive. It's a bright line rule. Higher security, higher consent standards, period.
Now, turning to individual empowerment. The CPPA grants you mandatory rights, like access and correction.
That's right. You still have to make a request in writing, but now organizations are obligated to actively assist you if you need help preparing it. They can't just point you to a web form and walk away.
And once that request is in, the organization has to provide the info in.
What was it? Plain language. That is critical. They can't drown you in technical jargon or unreadable database dumps, and they have to respond within 30 days.
30 days. Okay. And there was a surprising detail in the sources about sensitive medical records. How does that work?
That's where the law gets very nuanced. If the information you request is sensitive medical data, the organization can choose to provide that access through a medical practitioner.
Ah, so not directly to the individual.
Right. It's a risk management step. It acknowledges that just handing over raw medical data without context could cause real distress or harm.
That is a fascinating safeguard. Okay, let's talk about the idea that could really change how we interact with online services. Data mobility.
This is one of the most forward-looking parts of the Act. It directly challenges vendor lock-in.
What does it mean in practice?
It means that, subject to future regulations, an organization must transfer an individual's personal information to another designated organization, if both of them are part of a data mobility framework.
So if I want to switch my bank, I should be able to take my entire transaction history with me, seamlessly.
That is the intent. This framework will be the technical and legal scaffolding for it all. It cements the principle that the data is yours and you have the right to port it securely.
Platform portability.
This is a very big deal. But despite all these rights, we have to balance them against public necessity.
Right.
So the Act outlines a lot of situations where information can be collected or used without your knowledge or consent.
We're talking about key exceptions that let society function. What are the major ones?
They mostly fall into three buckets: safety, finance, and legal compliance. So you don't need consent to prevent or detect fraud. You don't need it for debt recovery.
And if the law requires it, like a warrant.
Exactly. A subpoena, a warrant, that always takes precedence. And there's also a specific exception for police work or other investigations.
How does that one work?
Well, information can be disclosed without consent for an investigation into a federal or provincial crime, but only if the organization has reasonable grounds to believe that getting consent would actually compromise that investigation.
So it prevents tipping off the bad guy.
That's the idea. It also covers emergencies, like notifying family during a disaster.
Okay, let's shift to organizational defense. The CPPA requires robust security safeguards. What's the standard they have to meet?
They have to be appropriate and customized. The organization has to consider the quantity, distribution, format, and method of storage of the information.
So 1 billion customer records in the cloud needs a bit more security than paper files in a locked cabinet.
Radically different security, yes.
And the moment of truth is when those measures fail. A data breach. What triggers the mandatory notification?
If a breach happens, the organization has to notify the privacy commissioner and the affected individual, if it is reasonable to believe the breach creates a real risk of significant harm.
And significant harm is the key phrase there.
It is, and the CPPA is very modern in how it defines it. It goes way beyond just financial loss.
What does it cover?
It's a comprehensive definition. It includes financial loss and identity theft, sure, but also bodily harm, humiliation, reputational damage, a negative effect on your credit, even property damage.
So it recognizes the psychological and social injury that these breaches cause.
It absolutely does.
Given those high stakes, let's talk penalties. The consequences for organizations that knowingly break the rules, like not reporting a breach, are severe.
They are designed to make compliance a boardroom priority. For the most serious offenses prosecuted on indictment, the fine is up to $25 million or are 5% of the organization's gross global revenue, whichever is greater.
Okay, hold on. Let's put that into context. Why the global revenue number?
Because the law is targeting big tech. A flat $25 million fine is frankly meaningless to a company with $100 billion in global revenue. It's a rounding error. But 5% of that global revenue, that ensures the fine is mathematically punitive no matter how big the organization is. Even on a summary conviction, it's up to $20 million or 4%. These penalties can be an existential threat.
So we've established how your data must be handled, but that only covers how it's stored. Now we have to look at how it's used in powerful new systems.
And that brings us to ADA, the Artificial Intelligence and Data Act.
ADA.
This is a proactive piece of legislation, which is rare. It regulates AI systems used in international or interprovincial commerce. The goal is to set common, enforceable requirements for these systems before they cause widespread harm.
And the focus is on risk mitigation, specifically prohibiting conduct that causes serious harm or biased output. Let's nail down biased output. What does that mean?
It means any content, prediction, or decision that adversely differentiates against someone based on prohibited grounds of discrimination, like those in the Canadian Human Rights Act, and does so without justification.
So think of a bank's algorithm that disproportionately denies loans to people based on their ethnicity or gender.
That's a perfect example. So under ADA, the people responsible for these AI systems have to first assess if it's a high-impact system.
What makes a system high impact?
Well, the specific regulations will define it more, but generally it's a system whose failure or biased operation could significantly affect your health, your safety, or your fundamental rights.
Okay, so once a system is deemed high impact, like an AI for medical diagnoses, what happens?
Mandatory requirements kick in immediately. They have to establish measures to identify, assess, and mitigate risks of both harm and biased output.
So they have to be constantly monitoring it.
Continuous monitoring, yes. To check for compliance and to see if their mitigation measures are actually working. It's a demand for constant due diligence.
And the transparency rules are just as tough as under the CPPA.
Absolutely. The responsible person has to publish a description of the high-impact system in plain language on a public website.
What has to be in that description?
Its intended use, how it was evaluated, and crucially, the mitigation measures that are in place. The public has a right to know how these powerful systems are supposed to work.
It sounds like the minister overseeing this act has some pretty unprecedented powers.
They do. If the use of a high-impact system results or is likely to result in material harm, the company has to notify the minister immediately. The minister can also just order an independent audit if they even suspect something is wrong.
That's proactive. But what if the risk is immediate, like right now?
That's the ultimate tool. If the minister believes there's a serious risk of imminent harm, physical, psychological, whatever, they can order the person to immediately cease using or making the high-impact system available.
So a mandatory kill switch for a dangerous AI.
A rapid one, yes.
Finally, AIDA introduces specific criminal offenses that go beyond just fines.
Yes, it creates serious consequences for malicious or reckless behavior. For instance, it's a specific offense to use personal information for an AI system if you know or believe that information was obtained illegally.
So, from a hack or something.
Exactly. It targets the use of scraped or stolen data to build AI models. And there's a second major offense.
Which is?
It targets anyone who, without a lawful excuse, makes an AI system available while knowing it could cause serious physical or psychological harm, or who is reckless as to whether it will.
Willful blindness.
Precisely. And the penalties for these AI crimes include massive fines and even prison time for individuals, up to 5 years less a day. The message is clear. Reckless AI deployment will be treated as a serious crime.
So what we've seen today isn't just an update, it's a full restructuring. The CPPA creates a new baseline for individual autonomy and organizational accountability, backed by those enormous financial penalties.
And ADA complements that by demanding proactive risk mitigation from powerful AI systems. It requires them to deal with bias and harm before they're deployed. And we now have this new enforcement body, the Personal Information and Data Protection Tribunal, to handle it all.
To loop back to accountability, I found the distinctions around the data lifecycle really revealing. The new framework has different standards for data that is merely de-identified, where there's still a risk of re-identification, versus data that's truly disposed of.
You mean permanently and irreversibly deleted or anonymized?
Exactly.
And that legislative distinction is key to everything. It raises this very important question you'll be hearing about for years. With millions of dollars on the line, how will companies practically and technically prove that data has been irreversibly anonymized versus just being made difficult to trace.
Right, because the difference between de-identified and disposed is the difference between compliance and a crushing fine.
It's a tightrope walk between utility and legal risk, and they'll need to prove that data can never be traced back to an individual. How do you prove a negative like that to a regulator? It's a huge technical and legal challenge.
That wraps up today's briefing on Bill C-27. The signal for today is accountability. Under the Artificial Intelligence and Data Act, you are no longer just responsible for your code working. You are criminally liable if your code causes serious harm or substantial economic loss because you were reckless. The government is no longer asking nicely for you to mitigate bias. They are mandating it with the threat of a tribunal that can take 5% of your global revenue. Before we go, a reminder for the leaders listening. Stop marketing to the masses. Start briefing the C-suite. You have seen the power of AI unraveled. Zero noise, high signal intelligence for the world's most critical AI builders. Now, leverage our proven methodology to own the conversation in your industry. We create tailored proprietary podcasts designed exclusively to brief your executives and your most valuable clients. Stop wasting marketing spend on generic content. Start delivering must-listen strategic intelligence directly to the decision makers. Ready to define your domain? Secure your strategic podcast consultation now at the link in our show notes. This podcast is created and produced by Etienne Newman, senior software engineer and passionate soccer dad from Canada. Please subscribe and share. Until next time, keep unraveling the future.